Knowing when to pause or stop an interview is one of the most important judgment skills for a workplace investigator. An effective investigator understands that the goal is not simply to obtain information at all costs. The priority is to ensure that the interview remains safe, fair, legally compliant, and capable of withstanding later scrutiny. There are several situations where continuing an interview may create legal or procedural risks, and the investigator must be prepared to pause the process and reassess the situation. The first situation involves a significant change in the legal nature of the matter, sometimes referred to as a change of jeopardy. This occurs when the seriousness or scope of the issue changes during the interview. For example, an investigation may begin as a workplace misconduct matter but later reveal information suggesting a much more serious offense. When this happens, the investigator should pause the interview and consider whether additional legal protections or procedures are required. The original purpose of the interview may no longer accurately reflect the situation, and continuing without reassessing the employee's rights could compromise the fairness and admissibility of the information obtained. A second situation involves requests for representation. In unionized workplaces, if an employee makes a valid request for representation under Weingarten rights, the investigator must stop and address that request before continuing. At that point, the employer may choose to pause the interview and allow a representative to attend, or in some circumstances, discontinue the interview and proceed based on the evidence already available. What is important is that the investigator does not simply ignore the request and continue questioning, as doing so may create significant procedural challenges. Another important reason to pause an interview is to avoid creating a situation that could be viewed as false imprisonment or improper coercion. Although employers may require employees to cooperate with legitimate workplace investigations, investigators must never use physical restraint, block someone's exit, lock doors, or suggest that an employee is not allowed to leave until they provide answers. If an employee indicates that they want to leave, the investigator should remain professional and allow them to do so. The organization may address the refusal to participate through appropriate management channels, but the interview itself must not become coercive. Safety concerns are another immediate reason to stop an interview. Investigators must always remember that protecting people is more important than completing a conversation. If an interviewee becomes increasingly hostile, aggressive, or threatening, the investigator should de-escalate the situation and consider ending the session. A simple statement such as, "It appears that this conversation is becoming difficult. Let's take a break and revisit this at another time," may be appropriate. If there is any indication of potential physical violence, the interview should be terminated immediately, and appropriate security procedures should be activated. The conduct of third parties can also require an interview to be paused. Representatives, including union representatives or support persons, have an important role in protecting fairness, but they cannot interfere with the fact-finding process. If a representative repeatedly interrupts, answers questions on behalf of the employee, or attempts to coach responses, the investigator should remind them of the ground rules. If the behavior continues, the interview may need to be suspended and rescheduled with an appropriate representative present. The well-being of witnesses and complainants is another important consideration, particularly in trauma-related cases. A trauma-informed investigator recognizes that some individuals may experience significant emotional distress when discussing difficult events. If a witness becomes overwhelmed, appears unable to continue, or shows signs of severe stress, the investigator should activate an exit plan. This may involve taking a break, changing the direction of questioning, allowing the individual time to recover, or rescheduling the interview for another time. The purpose of an investigation is to obtain reliable information, not to push someone beyond their ability to participate effectively. Investigators may also need to pause an interview when the scope of the investigation changes unexpectedly. For example, during a complainant interview, an individual may suddenly introduce numerous new allegations without enough detail to properly examine them. Rather than attempting to investigate everything immediately, the investigator may pause and ask the individual to organize the information, provide specific details, and identify relevant dates, witnesses, or documents before continuing. Similarly, in an admission-seeking interview, if a subject refuses to participate meaningfully, or refuses to provide an account, the investigator may decide that continuing the interview is no longer productive. The organization can then proceed based on the available evidence and document the individual's refusal to provide their perspective. Finally, an interview should be paused if the discussion unexpectedly reveals a serious matter outside the original scope of the investigation. For example, if a witness makes an unsolicited disclosure about a separate serious criminal matter, the investigator should stop and seek guidance from appropriate internal or legal resources before proceeding. This ensures that the information is handled correctly and that the rights of all parties are protected. Ultimately, pausing an interview is not a sign of investigative failure. In many cases, it demonstrates professional judgment. A skilled investigator knows when to continue asking questions, when to slow down, and when to stop. The strongest investigations are not those where the most information is collected, but those where information is collected through a process that is fair, safe, and legally defensible.